Welcome back to Legally Yours. We are in conversation with Vatsala, who's telling us all about property law, and we are taking in calls on phone and emails. We have another caller who is calling us now. Hello?
Hello.
Good evening. Can you hear me?
Yeah, I can.
What's your name?
This is Rahul.
Rahul. Rahul, may I know which city you are calling us from?
Bangalore.
Okay. Rahul, you're on air and you may please speak slowly and clearly, and our legal expert is out here to help you.
Okay. What I would like to know is upon buying a flat from a builder in a building under construction, what are the permissions and papers that one should check with the builder so as to ascertain the genuinity of the builder?
Okay. The first thing to do is to find out if it's going to be a high-rise building or not. The high-rise building requires many more permissions. Okay. A high-rise building is defined as more than ground plus 3 upper floors. Okay, so, if you are talking about 9 floors, 10 floors, 11 floors built on large acres of land, it is definitely a high-rise building, for which you have to have several permissions apart from the normal ones. Like firefighting permission, environmental clearance, Survey of India clearance, and these are the extra permissions, clearances from BWSSB and from KEB. So, apart from this, there are other permissions which are common to both high-rise building and non-high-rise building. They are of course sanctioned by the competent authority, and your title papers in terms of your parent documents, your encumbrance certificates, your conversion certificates, Katha, contracts between the landowner and developer, general power of attorney, joint development agreement. The most important thing to do is two things. One is check the original documents which should be in the custody of the landowner or the builder. And second, always get into a contract with a time bound limit for completion of construction. So that any overruns or delays can be compensated with a per square feet rate, which will protect you and protect any EMI or pre-EMI loans which you might have taken. Apart from that, as a general advice, I would suggest that you go in for very reputed builders who have completed past projects on time, so that you could rely more on them, because all said and done, it is a tedious procedure to go and enforce your rights in the consumer court after time delays. So, I think some caution is better than trying to fix it after the problem has arisen.
Rahul, did you get your query answered?
Yeah, I did.
I'm going to ask Vatsala a quick question on your behalf.
Okay.
Vatsala, is it important for the buyer to rope in a real estate lawyer and show all the paperwork to the lawyer? Because even if we see the originals as a consumer, I may not fully understand the implications of it. So, would you recommend to Rahul?
See, I answered Rahul's question on the premise that he raised what are the documents he needs to check. But I probably was amiss in not saying that all this has to be shown to a real estate lawyer who will track the title properly and who will be able to guide you. Sometimes some purchasers rely on opinion of the bank's lawyer, but my recommendation is, despite that, you have to go to your own lawyer, despite the developer's lawyer, despite the bank's lawyer, just go to your own developer, because several times I have been able to pinpoint lacunas, loopholes, safeguards which have not come about from other sources.
All right, Rahul, thank you for being and participating in our show. It was a pleasure. Yes, I think this is a very general problem and a general question that people have once they are buying in a new apartment, as to how to make sure that the legalities are all clear, how to make sure that the paperwork is clear, the titles are clear. So, is that the number one query that you have?
The bulk of the business is from individuals who come and who want to, who are investing 40, 50, 60, 1 crore, 1.5 crores on either a villa or on a flat or on a site or on a built house, and it is necessary that they should consult an independent lawyer whom they trust and who is competent to get your due diligence done, because a certain sense of thoroughness is required before you pump in so much money.
Correct.
So, that is has to be done, and most people are doing it.
Okay. I think we have a next caller.
Hello.
Hello. Hi. You're on Legally Yours. May I know your name?
This is Soumya. I'm calling from Bangalore.
Hi, Soumya.
Hi. I have a question to ask. Like, this question is regarding an ancestral property thing. Like, my mother is no more. She passed away like 10-15 years before, and I just want to know the property of hers. I mean, it was shared between all her brothers and sisters. So, since my mom is not there,
Yes.
I am entitled to that property as well. This property was sold about quite a lot of acres, which was sold about a couple of years before. And these people have already invested the money that they got from that in some other huge acres of land. My mom's brothers have already bought their houses and they've got settled and all that. But it's been 2 years till now. They're not showing any signs of giving me my share. So, but at the same time, they've not come outraged and said that I'm not entitled for the property. They won't give me a share or anything. So, I just want to know, as a precautionary measure, what can I, take?
Yeah, I have a couple of questions for you.
Yeah.
How did your mother get this property?
It is her father's property.
Okay, she inherited it along with her brothers and sisters?
Yes. Because they had to take my signature for the power of attorney when they had to sell the property.
Where is it situated?
It is situated actually in Kerala, close to Cochin. There's a place called Alua, so it's situated there.
Okay. And when you say it has been sold, do you mean that your uncles have sold this property?
Yeah, they have taken the power of attorney from all of us.
Okay.
That is from all their other brothers and my mom's other two sisters.
Okay.
And,
see, this is a simple matter of a property in which you have a share having been sold through by representing you as a power of attorney holder. Okay. What we do in such cases is we normally take the amounts due to each and every vendor in the sale deed directly from the purchaser in their separate names and deposit it in their separate bank accounts. If that has not happened, as it seems in your case, what you have to do is you have to enforce your right against your mother's brothers and ask for what is due to you. And since the cause of action is continuing in terms of them promising to pay you and not paying you, you have only two options. One is the option of sending a legal notice and asking for your money back from your uncles. The other option is an amicable settlement, because it could be difficult to proceed against your own relatives. Some people do find it difficult to do that. Correct. So, there is really no third course open to you, unless you are willing to, both of you are willing to go for arbitration and settle the matter, which is not going to be as tedious and cumbersome as the court. It is going to be a very informal settlement, and at the same time it will be a binding settlement, and you won't have the formality of going to court. You can mutually appoint an arbitrator who will hear the facts of the matter and pass a decision which you can abide by.
Okay, I have another question now. Here, is it like the kind of share that they will give me? Is it okay for them to give the amount that they wish to, or I have a certain amount?
No, the amount is predetermined according to the share which you had and the market price it fetched at the time of the sale made by your uncles.
Okay. Okay, thank you very much.
Yeah.
But I probably had a quick question here. She had a genuine question as to finding out what is the total due to her.
Yes.
Right? And is there any specific process or in place where she can see that this is the price at which the land was sold on what day, and so this is the price that is due to her?
See, what happens is the price always follows the quantum of share she has in the property.
Right.
The point is, most of the time what is reflected in the sale deed is only the tip of the iceberg. a lot of money passes hands which is under the table.
Absolutely.
So, it is very difficult for her, unless her uncles are fair and square and admit that this much money has been received, she cannot claim it now, because A, she has no way of knowing how much has been paid, and B, she has no basis to put her legal claims on. At least if she now shows the sale deed to a court of law or to an arbitrator, it will be very clear how much is due to her. But that much she can definitely claim. Okay. But it will be very difficult for her to claim without the cooperation of her uncles is the money which has gone under the table.
Okay. And suppose a lot of time has elapsed from the time the sale was made and from the time it occurred to her that she wants her share.
In her case, the uncles are continuing to promise to give her the money.
All right.
So, the cause of action, despite when the sale has been made, continues to arise, because she has been trying to get the money, and the promises have been are being continuously made to her. Okay. So, the cause of action stops when from the last known cause of action a period of 3 years has lapsed. Then it will be very difficult for you to claim your money back, because you have lost your right. But in many cases we find cause of action continues, because people are always trying to get the money back, and there has been some promises made, and
so even verbal promises hold good in this case?
Yes.
Okay. All right. With that, I think we have covered enough ground for this show, and thank you, Vatsala, for coming in and fielding all the questions from our viewers. With that, it's time for us to bid you goodbye, and we'll see you next week once again, same time, same place at Legally Yours. Thank you for watching the show.